Hi, welcome again to another lecture on the continuation of the lectures on persons and family relations law. This is the basic Philippine law and jurisprudence channel. Okay, our topic for today is proof of filiation. Okay, in the previous chapter, we have discussed how to challenge the legitimacy of a child conceived during the coverture of the marriage, the grounds, the persons who are authorized to challenge the same, and the period within which to challenge, to file the subject challenge to the legitimacy of said children. Now, let us go to filiation. Filiation, as you already know, is the relationship of the child to the father. Okay. So there are basically different ways of establishing filiation, whether legitimate or illegitimate. Okay, the filiation of legitimate children, according to Article 172, may be established through any of the following. Remember, Article 172 are the primary evidence of filiation. Okay? You may introduce it as evidence even if the putative father has already died. Okay? So what are these means or evidence, primary evidence to establish the filiation of children? First, we have the record of birth appearing in the civil register or a final judgment. So the birth certificate must either be recorded in the civil registry or pronounced by the court in a final judgment. Okay. Second, an admission of legitimate filiation in a public document or a private handwritten instrument and signed by the parent concerned. Okay, so we are speaking here of two documents. It is either a public document or a private handwritten instrument. Handwritten, meaning it is written using the personal penmanship of the putative father. Okay, what is the content of that document, which is either public or private handwritten? It must contain an admission of paternity or admission of legitimate filiation. And it must be signed. Okay, so those two contents must be embodied either in a public document or in a private handwritten instrument. Okay, now there is also a secondary form of evidence to establish the filiation of legitimate children. What are they? Okay, first, the open and continuous possession of the status of a legitimate child. Okay, which may be shown through pictures, through witnesses stating that you have enjoyed the open and continuous possession, have been treated by your putative father uh, as his legitimate child, and any other means allowed by the rules of court and by special laws. Okay. So Article 173 states that the action to claim legitimacy may be brought by the child during his or her lifetime and shall be transmitted to the heirs if the child dies during minority or in a state of insanity. So during the lifetime of the child, he may bring the action to establish his claim of legitimacy. Okay? And if he dies, okay, during the pendency of the proceedings, then that right shall be transmitted to the heirs. Okay? The action already commenced by the child shall survive notwithstanding the death of either or both parties. Now, why is there a need to establish legitimate filiation. Okay. Because legitimate filiation gives rise to certain rights. Okay. Once filiation, legitimate at that, is established, there are certain consequential rights that comes into force or that becomes effective upon establishment of legitimate filiation, such as the following: surname, okay, to bear the surnames of the father and the mother, okay, to receive support from their parents, their ascendants, brothers and sisters, to be entitled to legitimate and other successional rights. So surnames, support, legitimate or inheritance, these among others are the rights which automatically arise upon the establishment of legitimate filiation. Okay. How about illegitimate or legitimated children? Okay. Illegitimate children, according to Article 175, may establish their illegitimate filiation in the same way and using the same evidence as legitimate children. So, the same forms of evidence, either primary or secondary evidence, may be introduced by illegitimate children to establish their own filiation. How about the period to file the same? Okay, the action must be brought within the same period specified in Article 173, except when the action is based on the second paragraph, in which case the action may be brought during the lifetime of the alleged parent. Okay, so an action to establish filiation may be filed during the lifetime of the child. Okay. However, if your action is based on the second paragraph of Article 172, meaning secondary evidence like open and continuous possession of the status of an illegitimate child, you have to file the same within the lifetime of the putative parent. Why? Because you have to give the putative parent the opportunity to contest. If the putative parent is already dead, then his lips are already sealed, so he has no opportunity to contest. Now, why is it that when it is based on the first paragraph of Article 172, what are those? Primary evidence, like record of birth in the civil registry, or the in a final judgment, or the private handwritten instrument or public instrument wherein the putative father admitted paternity or admitted the legitimacy or illegitimacy, as well as signed the same, then there is no need, okay, to file the same during the lifetime of the father. Why? Because this can be established, okay, even when the father has already died. The handwriting of the father can be attested by experts. Okay? The record of birth is already a public document. Okay? And there must be an acknowledgement on the part of the putative father of the legitimate or illegitimate filiation. How about illegitimate children? What are their rights? With respect to surnames, illegitimate children shall use the surname and shall be under the parental authority of their mother, and they shall be entitled to support as well as one half of the legitim of a legitimate child. Of course, subject to the Revilia law, which allows the child to use the surname of the father. Okay, if he is acknowledged in the certificate of live birth, if there is an acknowledgement of filiation in the certificate of live birth. Okay. Only children conceived and born outside of the wedlock of parents at the time of conception were not disqualified by any impediment to marry each other may be legitimated. So we have actually three kinds of children. Okay, natural filiation, legitimate, illegitimate, and legitimated children. Now, for a child to be qualified to be legitimated, both spouses, okay, must at the time of the conception of the child were not disqualified or were not suffering from any legal impediment to marry each other. If, for example, one of the spouses is suffering from a disability, like, for example, if he has a subsisting marriage, okay, at the time of the conception of the child, and later on, okay, the wife of that spouse has died, making him eligible to marry the mother of that child, still the subsequent marriage of his parents cannot be considered as a legitimation. Why? Because at the time of his conception, one of the parents is suffering from legal disability to marry. Okay? Legitimation, how does legitimation take place? It will take place by the subsequent valid marriage between the parents. Okay? You must remember that legitimate and legitimated children share the same rights, meaning they have equal rights. Okay. The effects of legitimation shall retroact to the time of the child's birth. That is the reason why the law requires for the parents to both be not suffering from any legal impediment because of the retroactive effect of legitimation. The legitimation of children who died before the celebration of the marriage shall benefit their descendants. Okay? Can you impugn legitimation? Legitimation may be impugned only by those who are prejudiced in their rights within 5 years from the time that the cause of action occurs. Okay? Filiation is the judicial determination of the relation of the child to the father, mother, or ancestors. Okay, it is a filiation proceeding is a special statutory proceeding, criminal in form but in the nature of a civil action to enforce a civil obligation for the purpose of establishing parentage and the putative father's duty to support his child. Okay, now what are the means allowed by law to establish filiation? Act or declaration concerning pedigree, family reputation, judicial admission, admission of a party, and admission by silence. We may also add other scientific proof such as DNA testing, okay, to prove filiation because it is allowed under the pertinent circulars issued by the Supreme Court. Okay, we have the case of heirs of Cabais versus Court of Appeals. So, we are in the topic of proving filiation. So, the birth certificate, being a public document, offers prima facie evidence of filiation. And there is a high degree of proof that is needed to overthrow the presumption of truth contained in the certificate of live birth. On the other hand, as compared to a baptismal document is a private document, and that is not considered as conclusive proof of filiation. It does not have the same probative value as a birth certificate. It only proves the administration of the sacrament. Okay? But not the veracity of the declaration stated with respect to his kinsfolk or his parents. Okay? We have the case of Hilario versus Miranda. In this case, the issue is whether Magdalena is an intestate heir of both Antonio and Dolores. Okay. So, illegitimate or legitimate filiation, the action to establish filiation must be brought during the lifetime of the alleged parents. Specifically, if your ground for establishing filiation is one of those regarded as a secondary evidence under the second paragraph of Article 172. Okay. We held that acknowledgement of the putative father is essential and is the basis of an illegitimate child's right to inherit. If there is no allegation of acknowledgement, the action filed by the illegitimate child to be given a share in the estate becomes one to compel recognition, which cannot be brought after the death of the putative father. Okay, always remember that if the ground used to establish filiation, illegitimate filiation, is under the second paragraph, Article 172, meaning open and continuous possession of the status of an illegitimate child. Okay, you have to bring that action not only within the lifetime of the child, but also within the lifetime of the putative parent. Okay, why again? To give that putative parent the right to dispute or contest the allegation or claim of filiation. Okay, illegitimate paternity, according to the Supreme Court, is not paraded for everyone to see, but it is normally enshrouded in secrecy and kept hidden from the members of the legitimate family. The latter are not in a position to explain or contradict the circumstances surrounding the procreation of the illegitimate progeny, to inquire into those circumstances after the parent has died, when he alone has full knowledge thereof, when no one else can fully prove the truth or falsity of the alleged filiation of a claimant, is to penalize unnecessarily the legitimate family that constitutes one of the foundation blocks of society. In this case, Magdalena could no longer raise as grounds for recognition the evidence enumerated in paragraph 2, Article 172, since she could only have raised them during the lifetime of her father, who is now deceased. Okay? Illegitimate children are already given by the family code their status from the moment of their birth. There is therefore no need for an illegitimate child to file an action against his parent for recognition if he has in fact already been recognized by any of the evidences mentioned in Article 172. If, however, the status of the illegitimate child is impugned or he is required by circumstances to establish his illegitimate filiation, then he can do so in the same way and on the same evidence as legitimate children. Okay, Magdalena was an illegitimate child of Antonio. Since the law gave her the status from birth, she had no need to file an action to establish her filiation. It is not an effective impugnation that shifts to Magdalena the onus to establish her filiation. To rule otherwise will only embolden and encourage unscrupulous lawsuits against illegitimate children, especially those who enjoyed recognition under paragraph 2, Article 172, as they can no longer defend their rights after the prescriptive period has set in. It's the policy of the family code to liberalize the rule on the investigation of the paternity and filiation of children, especially of legitimate children. Okay, we have the case of Abelia versus Caballero. Okay, when filiation is established, again, there are rights which consequently result from the establishment of filiation, one of which is support. Okay, so when filiation is beyond question, support follows as a matter of obligation. An action for support may be directly filed where the matter of filiation shall be integrated and resolved. So there is no need first to file an action to establish filiation before you can file an action for support. You can actually directly file an action for support and then introduce your evidence of filiation in that action for support. So in this case, the issue is whether the Court of Appeals erred in ruling that filiation proceedings should have been first separately instituted to ascertain the minor child's paternity, and that without these proceedings having been first resolved in favor of the paternity claim, the action for support could not prosper. That was the very issue resolved in this case. So the court said, no, you need not file an action to compel, to establish filiation first before you can file an action for support. You can directly file an action for support, and in that action for support, introduce evidence regarding filiation. Okay. The judicial remedy to enable this is an action for compulsory recognition. Okay, the burden of proof in proceedings seeking to establish paternity is upon the person who alleges that the putative father is the biological father of the child. The recognition of an illegitimate child through a birth certificate, a will, a statement before a court of record, or any authentic writing has been held to be an acknowledgement of the child, and no further court action is required. An action to compel recognition could very well be integrated with an action for support. So in this case, that it is not needed, as I've said, to first file an action to compel recognition. You can directly file an action for support and introduce evidence of your filiation in that action for support. Okay, we have the case of Ara versus Pizarro. For a claim of filiation to succeed, it must be made within the perimeter period supported by the evidence required under the family code. So in this case, Romeo and William and Dr. Peli and Henry all claim to be the children of Josefa. Okay. Now, the plaintiffs filed a complaint for judicial partition of properties left by Josefa. Pizarro averred that she was the only legitimate and only child of Josefa. Okay, now, the issue is whether petitioners may prove their filiation to Josefa to their open and continuous possession of the status of illegitimate children. Remember, Josefa here already died. Okay, now, even despite the death of the putative parent, they wanted to establish their illegitimate filiation. What is the ground that they will use? The open and continuous possession of their status as legitimate children. The problem of the respondent, however, is that since he seeks to prove his filiation under the second paragraph, his action is now barred because of the putative father's death. Okay, to recall, petitioners submitted the following to establish their filiation. Okay, Garcia's baptismal certificate listing Josefa as his mother. Garcia's certificate of marriage, a picture of Garcia's wedding listing with Josefa, certificate of marriage showing that Alfredo and Josefa were married, and Garcia's certificate of live birth, which is a late registration showing he was born to Alfredo and Josefa. According to the court, birth certificate offers prima facie evidence of filiation. However, the circumstances surrounding the delayed registration prevent us from according it the same weight as any other birth certificate. In case of an illegitimate child, the birth certificate shall be signed and sworn to jointly by the parents, or only the mother if the father refuses. It shall not be permissible to state the name of the father who refuses to acknowledge the child, or to give any information by which the father could be identified. A delayed registration of birth made after the death of the putative parent is tenuous proof of filiation. We are unable to accord petitioner Garcia's delayed registration the same evidentiary weight as regular birth certificates. Although Garcia's baptismal certificate, certificate of marriage, and certificate of live birth obtained via late registration all state that Josefa is his mother, they do not show any act, declaration, or omission on the part of Josefa. Josefa did not participate in making any of them. Kay Josefa passed away in 2002. After her death, petitioners could no longer be allowed to introduce evidence of open and continuous illegitimate filiation to Josefa. The only evidence allowed under the law would be a record of birth appearing in the civil registrar or final judgment, or an admission of legitimate filiation in a public document or a private signed handwritten instruction by Josefa. So that is the moral of the story in the case of Ara versus Pizarro. You're invoking the secondary evidence to establish your illegitimate filiation under Article 172, paragraph 1, paragraph 2. You have to file that action within the lifetime of the putative parent. Otherwise, it will be considered as barred. San Agustin versus Sales. So in this case, Luis formally recognized brothers Teodoro and Ernesto as his children by epitasia in two public documents bearing his thumb marks. Okay, first, a notarized document formally recognizing the plaintiffs as their children, and a document solely executed by Luis, denominated as acknowledgement of children. So can you consider that thumb mark as a way of signing a document? Okay. During the execution and notarization of the documents, Luis could still write, rendering incredible the mere affixing of his thumbprints to the contested documents. That was the claim of the petition. However, Ernesto testified that Luis was no longer capable of writing his name as he was already blind and bedridden at the time that he affixed his thumb mark to the document. The Supreme Court held that a thumb mark has been repeatedly considered as a valid mode of signature, especially if the one who is signing is no longer capacitated to sign the same. Okay? Aguilar versus Shasta. Rodolfo filed a case for injunction against Edna, alleging that he is the only son and sole surviving heir of the Aguilar spouses, and that the titles of the lands were kept by Edna. Respondent claimed that the petitioner is not the son of the Aguilar spouses, but a mere stranger who was raised by the Aguilar spouses out of generosity and kindness of heart. Okay? Alfredo's SSS Form E1 satisfies the requirement for proof of filiation and relationship to the Aguilar spouses under Article 172. Said document constitutes an admission of legitimate filiation in a public document. Must remember that when, with respect to the SSS form, it states their beneficiary, and and the relationship will be required to be filled up. So pag nilagay niya doon, Alfredo Aguilar, son, then that is an admission in a public document. So it is primary evidence of filiation. Okay, so it may be brought during the lifetime of the child and even when the putative parent has already died. Okay? It was erroneous for the CA to treat said document as mere proof of open and continuous possession of the status of a legitimate child. Filiation may be proved by a public document or a private handwritten instrument signed by the parent concerned, and such due recognition in any authentic writing is a consummated act of acknowledgement of the child. No further action is required. Okay? The following rules are adopted. Where the private handwritten instrument is the lone piece of evidence submitted to prove filiation, there should be strict compliance with the requirement that the same must be signed by the acknowledging parent. So you must remember that there are two contents needed in primary evidence of filiation. First, there must be an acknowledgement of filiation, and it must be signed by the putative parent. Now, where the private handwritten instrument is accompanied by other relevant and competent evidence, it suffices that the claim of filiation be shown to have been made and handwritten by the acknowledging parent, as it is merely corroborative of such other evidence. Dolina versus Ballesera. This is a case of violation of Republic Act 9262 for failure of the putative parent to provide support, okay, over an unacknowledged child. Now, the issue is whether or not the RTC correctly dismissed Dolina's action for temporary protection and denied her application for temporary support of her child. Okay, Dolina evidently filed the wrong action to obtain support. The object of Republic Act 9262 is the protection and safety of women and children who are victims of abuse or violence. Although the issuance of a protection order can include the grant of legal support for the wife and child, this assumes that both are entitled to a protection order and to legal support. So the true object of her action was to get financial support, Ballesera being the father. He, of course, vigorously denied this. So he must file an action for support, not an action, not a criminal case for violation of Republic Act 9262. To be entitled to legal support, petitioner must, in a proper action first, establish the filiation. If the same is not admitted, the child's remedy is to file through her mother a judicial action for compulsory recognition. Illegitimate children are entitled to support, but their filiation must be duly proved. Dolina's remedy is to file for the benefit of her child an action against Ballesera for compulsory recognition in order to establish filiation and then demand support. Alternatively, she may directly file an action for support where the issue of compulsory recognition may be integrated and resolved. So, Dolina filed the wrong remedy because she filed a criminal case. Okay, instead of filing a civil case for support, okay, and then the recognition or establishment of filiation may also be the evidence on Filiation may also be introduced in that action for support, or he may file an action for compulsory recognition, okay, to establish filiation and then demand to support in the same action. Okay? Agustin versus Court of Appeals. So in this case, respondents Pe and her son Martin sued Martin's biological father, Arnel, for support. Okay, Arnel denied having sired Martin. So the issue is whether a complaint for support can be converted to a petition for recognition, and whether the DNA paternity testing can be ordered in a proceeding for support. Okay. Whether or not Martin is entitled to support depends completely on the determination of filiation. A separate action will only result in multiplicity of suits. Okay. In case of proof of filiation of paternity, DNA testing, which examines genetic codes obtained from body cells, could be resorted to. In assessing the probative value of DNA evidence, the court should consider the following: how the samples were collected, handled, contamination of the samples, procedures, etc. Okay, so for too long, illegitimate children have been marginalized by fathers who choose to deny their existence. The growing sophistication of DNA testing technology finally provides a much-needed equalizer for such ostracized and abandoned progeny. Okay, this is very interesting, considering that DNA evidence is not one of the grounds for the establishment of filiation under Article 172. So you must remember that the primary evidence would be record of birth, uh, public instrument, private handwritten instrument, acknowledging filiation, signed by the putative parent. Okay? O secondary evidence, open and continuous possession of the status of either a legitimate or illegitimate child, and any other means allowed by the rules of court. This is where the secondary evidence of DNA evidence can be considered. Okay, so my personal take on this is that DNA having been scientifically proven to establish a paternity by 99.999%, it should be considered as primary evidence instead of a secondary evidence of paternity, especially so if the specimen from the putative parent can be obtained even if he is already dead. Okay, Bernabe versus Alejo. In this case, Ernesto allegedly fathered a son with Carolina, okay, and was named Adrian Bernabe. Now, Carolina, in behalf of Adrian, filed a complaint praying that Adrian be declared as an acknowledged, illegitimate son of Ernesto, and as such, he be given his share in Ernesto's estate. Okay. The RTC dismissed the case on the ground that it is already barred. Okay. Under the new law, an action for the recognition of an illegitimate child must be brought within the lifetime of the alleged parent. The putative parent is given by the code a chance to dispute the claim, considering that illegitimate children are usually begotten and raised in secrecy without the legitimate family being aware of their existence. The putative parent should thus be given the opportunity to affirm or deny the child's filiation, and this he cannot do if he is already dead. Now, the issue to be resolved is whether Adrian's right to an action for recognition, which was granted by Article 285, has already vested prior to the enactment of the Family Code. Our answer is in the affirmative. Article 285 of the Civil Code is a substantive law, as it gives Adrian the right to file his petition for recognition within 4 years from attaining majority age. Therefore, the Family Code cannot impair or take Adrian's right to file an action for recognition, because the right has already vested prior to its enactment. Okay, so that is all for proof of filiation. Thank you for listening, and don't forget to subscribe.